minute. It's good to see you.
Good afternoon, Your Honors. May I reserve 4 minutes as part of my rebuttal? I'm Junie Gianguli. I'm from the Shelby County Bar, and I represent Cleotha Abston. Mr. Abston was charged in 2023 with the aggravated rape and kidnapping of Alicia Franklin. In September of 2022, he was arrested for the kidnapping and murder of Liza Fletcher. The aggravated rape and kidnapping of Alicia Franklin occurred in September of 2021. Those offenses did not garner any media coverage. Mr. Abston's murder of Liza Fletcher in September of 2022 garnered international media coverage. At trial, the state introduced a handgun that officers recovered when Mr. Abston was arrested in September of 2022. We submit that was error. Alicia Franklin described Mr. Abston using a handgun that was either black or silver. She described this handgun in very vague terms. She, like many other people, couldn't conclusively describe the handgun. Although the parties and the court took extensive measures, including filing thorough jury questionnaires, so we could question jurors to see if they had heard, so to speak, of Mr. Abston and his involvement in the Liza Fletcher case. We submit that the gun that was introduced alluded to Ms. Fletcher's murder. Specifically, the very first witness that the state called was Graham Hill. He was a task force officer with the Federal Bureau of Investigation, and he described that on September 4th or 5th of 2022, officers arrested Mr. Abston and then found a gun.
Are you saying that that was the reference to the case that garnered national media attention?
That was an allusion, yes, Your Honor.
Okay, that's what you're referencing. I thought I was missing something, a specific reference to the victim in the other case's name in this case. That's not what you're arguing?
No.
Okay.
At no point, to be clear, did anybody refer to Liza Fletcher at this trial. However, the state did call Graham Hill, who testified that on September 5th, 2022, officers arrested Mr. Abston, and during his arrest in September of 2022, they found this handgun. Alicia Franklin's events had occurred in September of 2021. I believe the exact date was September 21st of 2021. So we're looking at roughly an 11 and a half month difference in time between the events that led to Alicia Franklin reporting this attack and Liza Fletcher's murder. This handgun that officers recovered, I'm not sure if that was the gun. It could have been. To be fair, it very well could have been.
Are you talking about the gun in this case?
Yes, Your Honor.
Okay.
To be fair, it could have been. The gun that officers recovered in September of 2022 could have been the gun that Mr. Abston used in 2021. I'm not, at the same time.
Did you make that argument to the trial court? Is that, because I got a different impression from the briefs.
What I told the trial court is that there is no way to tell that if this gun in 2022 was the gun that Alicia Franklin described. There's absolutely no way. So how do you know it's the same gun?
Do they have to know, though? It's like you're challenging the trial court's 404B ruling, and it sounds like you're saying that there's not clear and convincing evidence that this was the gun that was involved with this particular victim that was discovered on him a year later. Or are you arguing that the balancing part of that test, where the danger of unfair prejudice outweighs that probative value, or that there's not a material issue?
Your Honor,
What was your complaint about the 404B ruling?
that the danger of unfair prejudice outweighs the probative value. The danger of unfair prejudice arises from several facets. Number one, Graham Hill is an FBI officer, and he testified about the number of law enforcement officers who were involved in Mr. Abston's arrest in September of 2022. Submit that jurors would certainly wonder, why are there task force officers from the Federal Bureau of Investigation involved in Mr. Abston's arrest in September of 2022? Additionally, Mr. Abston has an unusual name. It's not common like John Smith. So submit that although the trial court took extensive measures to make sure that the jurors had not heard of the Liza Fletcher murder, when jurors hear about Federal Bureau of Investigation, task force officers, hordes of Memphis Police Department officers being involved in an arrest, plus the name Abston in September of 2022, a logical inference is that Memphis jurors would tie 2 and 2 together.
You had a jury selection process, I'm assuming, that could have handled that issue on the front end, and there's no challenges to that here. And it seems like the argument I'm hearing today, it's pretty different from the one I was reading about in the brief, that the prejudice here comes from this, what seems to be speculation that the jury would have connected the dots between this case and Ms. Fletcher's case. I didn't pick that up at all in the brief, so this is kind of hitting me new.
Well, submit that, again, there is no way to conclusively determine that this gun in September of 2022 was the gun that he allegedly used in September of 2021.
Are we really talking then about 404B, or is this really an authentication issue?
I believe
Because if it was the gun and the state was able to show that it was the gun, it would be probative and relevant as to this instant offense. Wouldn't you agree?
I would, except there was no way for the state to prove that this was the actual gun, because the only description that Alicia Franklin provided was that Mr. Abston had a gun, and that gun was black and silver, and it was a handgun. Most handguns are black and silver.
Wasn't the testimony that she couldn't say with certainty that it was the gun, but it looked like the gun? Wasn't that her testimony about the gun?
I believe it was, and I'll defer to the transcript. It's just that most handguns look very similar. Most handguns are fairly small. Most handguns are black and silver. And most guns look have similar characteristics.
I guess I'm trying to get to what you're saying, what was prejudicial about this, because she said there was a gun. He used a gun, put it to the back of her head, all of that. The state says, did the gun look like this? She says, yes, it looked like that. Can't say for sure it was that, but she's live person testifying. This man over here put a gun to my head, raped me. Okay, so she's saying he used a gun, regardless of whether that was the gun or not. How is that prejudicial to your case?
Well, if it's not the same gun, then I submit that it is prejudicial, unfairly prejudicial, because it needs to be, in my opinion, the same gun, not some other gun used in some other crime.
Couldn't the jury, well, for one, as best I understand it, the jury never heard about this other crime. It seems like we're speculating a lot that, oh, well, the jury must have known this. We just don't know that to be true, is my understanding of the record. We'd have to speculate to get there.
And you didn't argue that at all.
I didn't.
You hear trial judges say this all the time, and most of the time they're absolutely correct. This goes to the weight and not the admissibility. Couldn't a jury look at this and say, well, you know what? Same guy had a gun. The victim said it looked like the one he had, and the jury can make of that what they will. Isn't that kind of what we have here?
It may be. At the same time, our position is that if it's a gun that was introduced at Mr. Abston's rape and kidnapping trial, it should be the gun that he used in the rape and kidnapping.
And you've already conceded, though, it may have been, right? Isn't that a determination for the finder of fact, the jury, which is, I think, what Judge Hickson was asking?
I mean, to be fair, I can't say that Mr. Abston had a different gun, but since Ms. Franklin was not certain that that was the gun that Mr. Abston used in September of 2021, we submit that it was error to allow admission of a gun that officers recovered 11 and a half months later. We also submit that the trial court erred by refusing to instruct the jury that the state of Tennessee had a duty to preserve the text messages. During testimony, Sergeant Shamika Love was on video speaking with Alicia Franklin, and this is, again, on video. And Sergeant Love asked to see Ms. Franklin's cell phone, specifically text messages between Ms. Franklin and Mr. Abston. And then, having reviewed the text messages and scrolling through the text messages, Sergeant Love chose not to preserve those text messages.
Didn't the defendant have the same text messages? Because they were between him and the victim in this case, right?
They were.
So what difference does it make?
Except we didn't get Mr. Abston's case until 2023.
Mr. Abston had access to his text messages just as much as the state did at the time. So we have plenty of case law that says so long as the defendant also has access to the same potential evidence, that there is no, I think you're arguing there was a Ferguson violation here.
That's correct.
Yeah, so.
Your Honor, we submit that that would be shifting the burden of proof as to the defendant. Because it's true that Mr. Abston had access to the text messages. It's true.
It was his text messages. Mm-hmm.
At the same time, Officer Love was looking at the text messages. She chose not to preserve them. The only reason she chose not to preserve the text messages is because they were favorable to the defense. If
What
they,
proof do you have of that? I mean, that's a pretty weighty allegation, so what proof do you have of that?
well,
If you don't have the text,
if they were incriminating, I submit that Officer Love would have preserved those text messages. If there had been a statement of admission, for example, Mr. Abston admitting that he had raped Alicia Franklin, common sense dictates that Officer Love would have photographed those text messages.
that's not what you said, though. You said that they must have been favorable to the defense, and that's why the officer didn't collect them. That's a big allegation. Do you have any evidence to support that?
I don't have any evidence to support that, but
Would you
if,
like to retract that statement?
yes, sir,
Okay.
had the texts been incriminating, I believe the officers would have preserved it.
Is there any dispute that they met on Plenty Fish, though, Mr. Ganguly, and they were exchanging some pretty graphic messages between the two of them, and that the victim didn't dispute at all that she was engaging in, I guess, sex for money, so to speak? That was the issue here, I think.
Your Honor, I think I'm
You can
past
answer
my-
that question. I
I can answer
was
that.
just looking at the value
Sure.
of these text messages when those things were not in dispute.
Well, Alicia Franklin provided a 48-minute statement to the Memphis Police Department. She did not tell Officer Love until the 33rd minute that she told Mr. Abston words to the effect that her time wasn't free. In other words, she didn't tell law enforcement until roughly 70% of her statement had elapsed that she wanted money from Mr. Abston in exchange for relations. So I submit there were severe questions regarding her credibility.
You still have your rebuttal time. Thank you, Mr.
Thank you.
Ganguly. State? Mr. Lundy,
Yes, Your Honor.
it's good to see you.
Good to see you, too. Thank you, Your Honor. May it please the court, counsel, my name is Will Lundy, and I represent the state of Tennessee in this appeal. Since my friend has focused primarily on the issue of the gun, I'll focus my time there as well. I'm a little surprised at the arguments that my friend is making because those arguments were not in the brief. The court seems to have addressed those issues very, very well, so I'm going to address the arguments that the defendant made in his brief. And basically, as I understand the issue regarding the gun, the question is, first of all, whether it's relevant, and then second of all, whether it was introduced essentially for an improper purpose under Rule 404B. And I will admit at the outset that this gun was not maybe not particularly probative. I mean, we are talking about a gun that was found, in a year after this offense. But as the court is well aware, relevance is a low bar. It's a low standard. The victim consistently and repeatedly testified that the defendant threatened her with a gun and that he used this gun in the course of raping her. She described the gun to Lieutenant Love as a black handgun. And so what we have in evidence in this case was actually introduced as a photograph of a gun that agent, actually I believe it was a police officer who actually took the photograph. But it was a photograph of the gun laying, quite frankly, harmlessly inside the vehicle that the defendant was driving at the same apartment complex where this rape occurred. And I want to point out, this wasn't an AK-47, this wasn't an AR-15, it wasn't a shotgun, and it wasn't a silver revolver or even a bicolored handgun. There are lots and lots of different permutations of guns, as this court is well aware, and the victim described a black handgun. And she looked at the photograph at trial, as Judge McMullen, as you pointed out, and she said, yeah, that looks like the gun that he used. I don't think it has to be the exact gun that he used in order to be relevant. It just has to have any tendency to make the existence of any fact of consequence, more or less probable than it would be without it. And that's really the standard that we have, and I think it meets that. And as far as the 404B rule is concerned, the defendant argued in his brief that the only possible purposes for offering this gun were to prove that the defendant had a propensity for violence or to inflame the passions of the jury. And again, on that front, I would just argue that no, that's not true. First of all, this was a photograph of a gun lying on the floorboard of a car. It was a GMC, so it would have been an SUV. But this wasn't offered to show that the defendant has a propensity for violence. He wasn't using the gun. He wasn't doing anything violent with it. It wasn't offered to inflame the passions of the jury. It was literally just a picture of a gun. Instead, it was offered simply to corroborate the victim's testimony that the defendant used a black handgun when he raped her. And again, as far as if this was error at all, it was harmless. And I think the jury is smart enough to look at the situation and say, well, yeah, but the guy could have gone out and bought this gun in the last year. Or any other number of things. So what this goes to, Judge Hickson, as you pointed out, is the weight of the evidence rather than its admissibility. And because, just because the weight of the evidence wasn't all that significant, there was no prejudice here.
How harmless would it be? How would you describe, like sometimes we see that this court will describe the nature of evidence as overwhelming proof of guilt. How would you describe it in this case?
In my brief, I said I used the word overwhelming, and I think I stand by that, Your Honor, because when I think about the evidence in this case, obviously, first of all, we have the victim's testimony, and she was consistent across the board, not only with her testimony at trial, but with her statements to police the night that this happened. We also have testimony, and of course she repeatedly said that he used a gun and threatened her. And so really the only reason that this is relevant is to corroborate the fact that she had a gun. And I would say that there is other evidence that would demonstrate that the defendant used a gun in this case. And again, we have her testimony, and besides that, what we have is the night of the offense, we have Officer Hardville testifying to the victim's appearance and behavior. She was crying, she was frantic, her hair was all over the place. And she's still quiet and crying and tearful later on when she's examined by the forensic nurse, which is all consistent with a woman who has undergone a very traumatic experience. And as the court is well aware, based in the evidence, the victim here went into this encounter expecting a sexual encounter. She and the defendant had engaged in a contract that would be void as a matter of public policy, to put it in law school terms that may be a little more sensitive. But in any event, she went into this night expecting a sexual encounter. And so then we have this evidence that she's a mess immediately after this encounter. And also,
is there forensic corroboration of her account?
As far, what do you mean, Your Honor?
Well, you mentioned the sane nurse. I'm not asking for many details here, but was there forensic corroboration?
His DNA was found inside of her, if that's what you're referring to. But one thing I do want to point out is that the forensic nurse, Nurse Prater, and this is exhibit 13. She observed no physical injuries on the victim. So how do we get this person who is obviously has gone into this encounter expecting sexual activity? Now she's really in a situation where she's undergone something very traumatic. It's very obvious, but she has obviously not been overpowered by the defendant, because if she had been, you would expect bruises, you would expect scratches, you would expect some kind of physical evidence on her person that would suggest this woman has been in a fight. There was none of that. A gun readily explains why she didn't have these injuries on her because, again, he threatens her with a gun. He can use that gun at any time and kill her, and so it overcame her resistance to his advances. And so just in light of all of the evidence that comes in, yes, I would say it's overwhelming, and that the jury believed everything that the victim testified to, and therefore, the inclusion of this photograph of the gun is harmless.
Well, they've accepted her. I mean, this case turns on her credibility.
That's right.
Would you agree?
Yes.
As to what happened.
Absolutely.
Whether there was consent or force or coercion, however
Yep.
it was charged.
Yep.
It turns entirely on her credibility.
Yep.
If the gun was admitted erroneously, and what this case turns on is the credibility of the victim, could we really say that it was harmless for the jury's going to hear, you know what, I'm kind of on the fence about this one, but here's this guy a year later running around with a gun still. Yeah, I'm going to convict him. I mean, isn't that possible?
It's possible, that the jury could have, but, the standard is that, in order for this error not to be harmless, it has to be more, the error is not harmless only if it more probably than not had a substantial and injurious impact on the jury's decision-making. And in light of the way that the evidence came in, as I just described, there's more than just her testimony that he used a gun. There's, again, just this... just the nature of the encounter and the way the evidence comes in with Officer Hartville's testimony about her, her appearance, about her demeanor, even later on in the day with Nurse Prater and her demeanor. She's still upset, obviously has been through something very traumatic. And again, there's no evidence that there was, that her powers of resistance were overcome by just physically overpowering her, and so which strongly suggests and corroborates her testimony that yes, there was a gun involved. And so in light of that, I would say yes, this is harmless. Could it? If the standard was something where it was more favorable to the defendant, then we may be talking about something different. But again, the error is only not harmless if it more probably than not had a substantial and injurious impact on the jury's decision making, and I just don't think we have that here.
Can you refresh my memory on the gun charge that the defense wished to be bifurcated? Was the allegation that the gun that was unlawfully possessed, the one that was found on him when he was arrested, or at the time the rape was committed? It
was at the time the rape was committed, is my understanding, Your Honor. And as far as, I'm going to briefly touch on the Ferguson issue. Judge McMullen, your answer to the defendant's question, or the defendant's response was, I think, spot on. These were the defendant's text messages. He had access to them at all times because they were his text messages, and therefore the state had no duty under Ferguson to preserve them. And I'll just leave that issue there unless the court has any other questions. Does the court have any questions for me on the bifurcation issue other than yours, Judge Sword? If the court doesn't have any questions, I would just...
Let me ask you this.
Go ahead.
I think we've seen language and opinions that says bifurcation is a better practice.
Yes.
Would it have been the better practice in this case?
I don't know if it would be the better practice in this case. And, I was thinking about this issue coming into today. And so we have these sort of two different approaches that can be taken, that this court has approved of both. And it said, yes, it would be the better practice to bifurcate. But we have this other practice where you have a stipulation where the defendant just stipulates. That practice is exactly what happened here, and this court has approved it over and over again. So there may come a day where, this court wants to double down on Faust and say, yeah, you know what, we have to do this. I would say today is not that day, and mostly because we have two places in the record where the trial court gave curative instructions. I mean, essentially, in order to hold that here, we'd have to hold that this is some kind of incurable, like, structural error, and no one's asked for that, no one's going there, so I don't want to go there with this case. The other problem I have with this, and I'm just looking through the case law, what I don't see is any sort of standard for how a trial court can say, okay, bifurcation is absolutely required here, and this, the stipulation would be an abuse of discretion. I don't see a standard where a court can look at that and say, here are these two options. I have to go with A or B in this scenario. If we had that kind of standard, maybe we could apply something, but in the absence of that, I just, I don't know. What we have right now is these two different methods that the court has both approved. And so I would ask the court to affirm on that front. The only other argument that the defendant has made is that the evidence was insufficient. His argument is based entirely on the credibility of the victim, which this court does not second-guess the jury's credibility determinations. So if the court has no further questions for me, I would ask this court to affirm, and I am prepared to cede the remainder of my time.
Thank you, counsel.
Thank you, Your Honors.
Mr. Ganguly?
Your Honors, we submit that the proof was absolutely not overwhelming. I say that because if the court were to review the record, one finds that on Thursday of the trial, during jury deliberations, they asked the court words to the effect of what happens if we're deadlocked and can't reach a decision. That's a question in form of a note that the jury sent to the trial court. That is not a sign of a case where the proof is overwhelming. Other signs that the proof wasn't overwhelming were that Alicia Franklin didn't call 911 after she met Mr. Abston. She called a friend that she had met online and had met for lunch just once. So as opposed to calling 911 and reporting a rape, she called someone she barely knew, had met only once, and seen only once.
That individual had law enforcement ties, correct?
That individual was an officer with the University of Tennessee Health Science Center. She wasn't affiliated with the Memphis Police Department.
That individual advised her on what to do in terms of calling the police because the victim really didn't know what to do, and also responded. I mean, I'm just trying to give context to your statement. I think it's a good point that, we're talking about harmless error and the impact of the evidence, because it is really a credibility question. So it's well taken. I just want to keep it in context of who that person was.
Thank you. Also, Alicia Franklin had a pending violent charge in the Shelby County courts. She had been arrested and was in the process of being indicted for aggravated assault.
Are you saying that her testimony was somehow swayed? Did the state make an agreement with her? What's the point of that?
Well, in terms of credibility of witnesses, in terms of whether a witness is particularly believable, of
Well,
whether...
that argument might hold some if it was perjury, but you're talking about an offense against a person or a violent crime. How is that impacting the credibility? I guess I'm trying to see your
Sure.
point there,
Well,
other than she picked up a charge.
that's true. I understand the court's perspective. Aggravated assault is a Class C felony. Felonies, under Rule 609, I believe, may be used for impeachment purposes.
Had she been convicted yet?
She had not been.
Okay, well, you can't use 609. Was she cross-examined about this pending charge at trial?
She was.
Okay.
She was. So, but,
So the jury considered it and
yes, sir.
gave it what due it was worth, right?
Yes, sir. At the same time, if we're talking about whether the proof was overwhelming, submit that it was not. We respectfully ask for Mr. Abston's convictions to be reversed.
Thank you, Mr. Ganguly. The matter will be taken under advisement. Excellent briefing and argument by both parties. We really appreciate it.
Thank you.
We don't say it enough, but we do.